Okay, great. I think we're ready to go ahead and get started. Good afternoon, everyone. My name's Stephanie Bowe. I'm with the Louisiana State Bar Association, and welcome to our Law Talks virtual workshop series. Today, our Law Talks is on how to make a will, powers of attorney, and living wills. And we have attorney Joseph Ballard with the Pro Bono Project presenting on these important topics. Before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. So questions will be taken at the end if time permits and answered live. If you are watching at a library, you may either walk up to the computer to ask to submit your question through the library staff. If you are watching by Zoom, please submit your questions in the Q&A section. And if you're watching on Facebook, please submit your questions in the comments section. Please do note that these comments are public and accessible by anyone during and after this presentation is over. Also, please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on the information provided in this presentation without first seeking legal advice from counsel in your relevant jurisdiction. If you need help or assistance finding legal help in Louisiana, you can go to the LSBA's Find Legal Help page, and we'll provide some more information on that later in this presentation. The LSBA's inclusion of a program is not deemed to be a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on these programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentation or materials were free of errors or will continue to be accurate. Statements in these presentations and materials should be verified before relying on them. Any opinions expressed are those of the speaker, and they do not necessarily reflect opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. As I mentioned, we have attorney Joseph Ballard with us today from the Pro Bono Project. He's the managing attorney over at the Pro Bono Project. His email address and a link to the Pro Bono Project's website is listed on this page if you'd like to reference it after this presentation is over. For those that don't know, the Pro Bono Project is lawyers who serve low-income clients in 6 parishes, so in Orleans, Jefferson, St. Bernard, Plaquemines, St. Tammany, and Washington. They have offices in downtown New Orleans as well as in Covington, but they still serve all of those 6 parishes. They do have a brochure list of what services they can provide, specifically as it relates to wills and powers of attorney. They do write wills and powers of attorney, but they do not do any trust work. The current types of cases they handled are listed here. So if you ever find yourself having one of these issues and you're in one of their parishes, you may be able to qualify for their services. So with that, today's presentation is going to cover wills, powers of attorney, and living wills, and I'm going to turn it over to Mr. Ballard to take it from here.
Hello, everyone. Can we go to the next slide, please? Um, the first topic we're going to cover is wills generally, but before we get to that, there's a concept called estate planning, and what lawyers mean by that is um, giving some thought ahead of time, usually consulting with an attorney, not always, but giving some thought as to what you want to happen after you die to your property and actually to your body as well. So, estate planning is important because it allows you to choose what happens to your property after you die. It makes your intentions known to family and friends. And that sounds kind of obvious, but we live in a society where people pretend death doesn't even exist. It's a taboo topic. Nobody wants to talk about it. Nobody wants to deal with it. So, you may assume that your family and your friends know what you want to happen after you die, but they may not because nobody might ever talk about it. So, this is your chance to give it some thought and to take some action to make sure that your wishes are communicated and your intentions are known. Estate planning provides clear directives and support for the care of minor children, or at least it can if you do it right. It can reduce conflict among family, friends, and business associates. It can simplify the legal transfer of property. It can protect the investments you've made in yourself and in your financial well-being, preserving them for those you leave behind. So that's why we bother to spend time and effort to do estate planning. Let's go to the next slide, please. Uh, when we talk about estate planning and wills and powers of attorney and all that, necessarily we're going to be using some language that is not necessarily part of your vocabulary of your everyday life. So there are words like estate, community property, last will and testament, probate, succession, testate, intestate. These words are not all that difficult to understand, but they are not necessarily part of your bag of words that you use to conduct your everyday life. The general rule is that your estate, that's the first thing we'll consider. Your estate is all your assets plus all your debts. So you might own real estate, cars, boats, cemetery plots, consumer goods, household items, clothes, jewelry, guns, tools. Um, and you also own debts. You know, you might have a Visa card that you owe money on, or, you know, revolving credit accounts and things like that, a mortgage. So all your assets and all your debts together make up your estate. And if you are married and domiciled in Louisiana, the general rule is that you are in a community property regime. And the lawyer has to figure out which of your assets and which of your debts are community property and which are the separate property of you and your spouse. The general rule in Louisiana is that property you acquire and debts that you take on after you get married are community. That means they're owned half by you and half by your spouse, and that each of you is responsible to pay the whole thing, but you can seek your reimbursement from the other spouse. So basically, for community property, you and your spouse are what some people would refer to as co-owners in division of the asset or of the debt. Now, just because you're married doesn't mean that everything you own is community property. You might still own separate property that belongs to you alone. Your spouse may own separate property that belongs to them alone. And the most common types of separate property are property that one of you inherits, even if you inherit after you are married. Also, property owned before marriage. So if you buy a house before you get married, that house is your separate property. If your spouse buys a house before you get married, that house is your spouse's separate property. If you buy a house during the marriage, it's community property. The other big category of separate property among married people is donations that are made to one spouse individually. So if your Aunt Lucy gives you her favorite diamond ring, it is your separate property, even if you're married when she gives it to you. Now, if you are married and in a community property regime, your estate is all your separate assets and debts plus half the community's assets and debts. So let's go to the next slide, please. There are certain things that are not part of your estate. Annuities, IRAs, life insurance policies, retirement and pension plans, U.S. savings bonds, transfer on death investment accounts, and payable on death bank accounts. These are all contracts, and what happens to that money in that instrument depends on what the contract says. So these are all types of contracts that say when you die, this money goes to the beneficiary that you designate in the contract. So if you want to know who gets your annuities after you die, or your IRAs and your life insurance proceeds and all that stuff, read the contract, because the contract will say that there's a designated beneficiary. It's whoever you designated when you entered into the contract. But these um, types of things never come into your estate. The payments go directly from the contract to the beneficiary, never goes into your estate, never comes out of your estate. It's never part of your estate. Let's go to the next slide, please. The next kind of lawyerly word we want to talk about is the word succession. And I hear this a lot, variations of this. My father died last week. 2 months ago, he told me that I would inherit his house. I'm living in his house now. I'm paying taxes on the house now. Am I the legal owner of the house? Well, the answer to that is no, you're not, at least not yet. Not even if you're paying taxes on it. You have to do a succession. So when dad died, the house became legally owned by his estate. The succession is how ownership is legally transferred from the estate of the dead person to the next person who owns it. So succession is just a word in Louisiana that refers to the legal process for transferring legal ownership of the dead person's property to the next owner. So, for example, let's talk about two people who are still alive. I sell you my house. You and I enter into a contract and we get a piece of paper called an act of sale. And that act of sale legally transfers ownership of the house from me to you. Well, the difference with the succession is I'm now dead. Okay, it's not between two living people, and so if my estate owns the house, how does that become legally your property from the estate? And the answer is through the process of succession. Let's go to the next slide, please. So the overview of the succession process is that a person dies and an heir, and put a little asterisk by the word heir there, an heir hires a lawyer, and if there's a will, he gives the will to the lawyer files a succession in court. At the end of the succession proceeding, the judge signs a judgment of possession, and the judgment of possession acts just like an act of sale or a deed to a piece of property. It makes the heirs the legal owners of the property. So the property is now passed from the estate to the next group of owners. So to probate a will in Louisiana means that you file a will into the record of the succession proceeding in district court, and you have the court give effect to the will's provisions. That's the general overall contours of it. That's not 100% of the picture, but that's kind of the general idea. Next slide, please. Now, what if the person who I here have chosen to call Steve, what if Steve dies without a will, or what if Steve dies with a will that is invalid? Well, if the value of the estate is $125,000 or less, the legal heirs can file a small succession affidavit in the parish conveyance records instead of filing a succession in district court. That procedure is cheap and it's fast. It really took off after Hurricane Katrina, as particularly banks were trying to clear title to land, and the succession procedure, the small succession procedure, was given new life after Katrina and is very popular. It's widely used now. If the value of the estate is over $125,000, heirs can file an intestate succession in district court, and they also, if there is a will, you file, again, 125 or less, you can still do a small succession affidavit even if there's a will. That's a recent change in the law. Or if it's over $125,000, then whether there's a will or not, you file the succession in district court. So intestate means without a valid will. Testate means with a valid will. So you file a testate testate succession. If there's a will, you file an intestate succession if there's either a no will or the will is invalid. Next, please. Now, what happens in the Louisiana law of intestacy is there's a series of statutes that say what happens to property if somebody dies without a will. And basically, what happens is the state makes a guess as to what they think the average normal person would have wanted to happen to their property, and they just cast that in stone and make it a rule that they're going to apply anytime there's no valid will. So if we take an example of a person who dies who was married and in a community property regime, the basic rule is that the surviving spouse gets all of the dead person's community property, plus the surviving spouse already owns their half of the community property. So 100% of the community property is now to the surviving spouse, and it instantly becomes separate property of the surviving spouse. Now, the dead person's separate property might go to the surviving spouse, but it might not, because under the intestacy rules, that is, a person dies without a valid will, the first thing that happens is if the dead person has descendants, that is, children and grandchildren, great grandchildren on down the line, if there are living descendants, then those descendants split the estate, and the surviving spouse gets a usufruct over the community property. So that means that in that situation, if you've got a living child when you die and you die without a will, well, your spouses get their half of the community property plus your half of the community property, but the separate property is going to go to your children with a usufruct in favor of the surviving spouse. Usufruct is a technical legal term in Louisiana. There are three kind of Latin words that crept into our French-based law here: usus fructus and abusus, and those are considered the three primary things that owners do with property. And that is, usus means you have the use of property, fructus means that you get the fruits of the property, such as if it grows crops, the crops are yours. If you have the right of fructus, if there's a house that you can charge rent on it and turn it into rental property, the rents are fructus. So if you have a usufruct over the property, you have the right to collect rents on it. And then abusus is the right to sell or mortgage the property. So what happens in this situation is that your children would get your separate property, but over the community property, your spouse would have a usufruct. Now, it's important to realize in Louisiana that you're either married or you're not. There's no legal separation in Louisiana. I mean, as a matter of fact, there is, but it doesn't have any legal effect. So if you're married until the judge signs the divorce judgment. So for example, every once in a while, somebody will come in and say, all right, well, here's the situation. Daddy died, and I'm the child, I want to open the succession. Or daddy died, I'm the surviving spouse. We've been separated for 20 years but never got a divorce judgment. Well, they're still married for purposes of intestate succession, even though nobody may think that that's the way it works out. So if you're married and you have no descendants, then the dead person's brothers and sisters and their descendants, so nephews and nieces, would get the separate property subject to a usufruct in favor of the parents. And strangely enough, if the married person, if the dead person has no brothers and sisters left, but has living parents, then the parents take that separate property, not the surviving spouse. So again, the whole reason I'm going through this is because you need to realize that if you die without a will, the state will have rules to figure out who gets your property, but it may not be who you want to get your property. So if what the state's going to do with your property in the absence of a will is not what you want, write a will so that you can tell everybody, no, I don't want it to do that. I want it to do this. So there are these categories of takers. So the state looks to see, do you have descendants? Do you have siblings? Do you have parents who are alive? If you don't have any descendants, siblings, or parents, is there a surviving spouse who finally gets everything? If there are none of those people alive, are there more remote relatives, second cousins and great aunts and things like that? And if they just can't find any surviving spouse or relatives at all, then when all else fails, the state is going to take everything. Let's go to the next slide, please. So if you want to think about the question, do I need a will at all? Well, the answer is no if the Louisiana laws of intestacy will distribute your estate the way you want. I'll give you an example. I have a good friend, a very sophisticated, high dollar A-list attorney, litigator, real great guy. He doesn't have a will. And he doesn't have a will because he's been married only one time. He's still married to his wife, and he has one child. And under the Louisiana laws of intestacy, if he dies without a will, the property's going to go exactly where he wants it to go. So that his wife's going to get her half of the community, and the separate property is going to go to the daughter, and the community property that goes to the daughter is going to be subject to a usufruct in favor of the wife until death or remarriage. So that all works out exactly the way he wants. He's happy without having a will. Well, that's fine. But if you're complicated, if your situation's a little more complicated than that, you may want to get a will. And some things to consider about this are, first of all, you know who your relatives are today, but you don't know who your relatives are going to be when you die. You don't know, am I assuming that my brother's going to outlive me? Am I assuming that my children are going to outlive me? Um, you know, my mother might have assumed that I was going to outlive her, but I mean, she's 101. I mean, she might outlive me at this point. Who knows? So you don't know necessarily who's going to be around when you die. So that might cause you to say, well, maybe I better write a will and not just leave all this to chance. Uh, what if you leave real estate that's inherited in equal shares by co-owners, some of whom have foolish ideas about what to do with the property? You have three children, and one of them is just a runaway alcoholic with a ne'er-do-well who's never held down a job, doesn't have the sense to get in and out of the rain. And if he's got equal rights over what to do with the property's probably just going to fall down around his ears. Do you really want to leave your property to people, leaving all this up to chance? What if you want one particular person to be the executor of the estate? What if you want to leave more property to some people and less to others? What if you want to leave something to a non-relative? Remember, these intestacy provisions only deal with relatives. There's nobody in that universe who can take under intestacy who's not a relative. And then finally, what if you get really old and you die last and there's just nobody left? There are no blood relatives around. Do you really want the state to take all your estate, or would you rather leave it to a charity? So depending on your answers to those questions, you may decide that you want a will. Let's go to the next question. Next slide, please. One of the things I said earlier is the great thing about a will is that it lets you decide what happens to your property after you die. And that's true, but there's an asterisk there. And the question is, well, are there any legal restrictions on how you can dispose of your estate in a will? And the answer is yes. The most serious one, the most glaring one, is the case of forced heirship. Louisiana used to force you to leave your property or a portion of your property to your children. that rule has been modified through the years. And the current state of the law is that if you have children who are under age 24, they're forced heirs. You have to leave them a certain amount of property, a certain percentage of your estate. However, you are also forced to leave a certain percentage of your property to children of any age who are unable to care for themselves. They're considered forced heirs. And sometimes that rule can apply to grandchildren. And the amount of property that you have to leave them if someone is a forced heir by virtue of being either under 24 or being disabled is a quarter share of the property for one child, and it changes depending on him if you have more than one child who is a forced heir. Now, within that universe, there are also rules for disinheriting. You hear the word disinheriting all the time. I want to disinherit my son because he's, turned his back on me and, stolen all my money and tried to kill me and whatever. The rules of disinheritance only apply to forced heirs. So if you have a child who is over 24 and not disabled, you don't have to bother disinheriting them because they're not a forced heir to start with. You just leave them out of the will. You just don't leave them anything. But if you have someone who you have to disinherit, that is, they are a forced heir, and the only way not to give them a part of your estate is to disinherit them in the will, then there are rules for that. So you have to do it in a valid will. You have to do it for one of 8 specific reasons listed in Code Article 1621, and reconciliation will extinguish the disinheritance. Also, if there is a forced heir, there are rules of collation. And collation is a concept where if you think about a will as being a donation in anticipation of death, it's a donation. Well, there's another kind of donation under the law, and that's a donation between 2 living people, which we refer to as a donation inter vivos. So collation is a set of rules saying you can't make donations to some people to cut out or to diminish the amount of your estate that you have to leave to a forced heir. So you can't have $100,000 estate and your forced heir is going to be entitled to $25,000. But the way you get around that is you donate $80,000 to your other people that you want to have the money. Doesn't work. Collation's going to claw that money back. It's going to reestablish the whole pie of the estate and make sure that the forced heir gets their portion of it. It's very, very complicated. There are probably 30 separate code articles dealing with collation. And it's a headache to try to figure all that out. If you're in a collation situation where it's important to you to understand those rules, you really need to consult with an attorney about that. Okay, let's go to the next slide, please. I keep saying, so and so dies without a valid will or with a valid will. So just because you have a will written on a piece of paper doesn't mean it's valid. There are only 2 kinds of valid will in Louisiana right now. That is a holographic will and a notarial will. This, as far as I'm concerned, is a big improvement in the law because back when dinosaurs roamed the earth and I had to prepare for the bar exam in the old days, there were many more kinds of wills than there are now, and some of them were pretty bizarre sounding. But now we only have two kinds of valid wills that are recognized. A holographic will is one that is entirely written, dated, and signed in the handwriting of the testator, so handwritten will. I see a surprising number of wills that purport to be holographic wills, but they're not. In other words, I see wills that are not valid because they're not a valid holographic will and they're not a valid notarial will. And the most common screw up I see in this area is to see someone who has a typewritten will that is hand signed, or a a combination handwritten typed will that's got a notary seal on the bottom of it, but no attestation clause. So there's no mix and match with this. If you have a holographic will, you need to write it out in your own handwriting in one document. It doesn't have to be just be one page; it could be multi-page, but it needs to be written entirely in your hand. You have to sign it at the end, and you have to date it somewhere on that document. Now, if you sign the will and then you come back later and you make a change to it below your signature, you're playing with fire, because a court can either give effect to that language or not in the discretion of the court. So, not a good idea to do that. If you do a holographic will and you come back and need to change something, tear up the old one and write a new one. Um, the other kind of valid will in Louisiana is notarial. Now, a notarial testament, that notarial will, is written on the computer, printed out, and it's signed and dated by the testator. That's the person making out the will, in the presence of a notary and two neutral witnesses. And it has an attestation clause on the bottom of it. There is an article in the Louisiana Civil Code, it's Article 1577, that tells you exactly, word for word, what should be in the attestation clause. There are wills that have been held invalid in Louisiana because they're a notarial testament. They're machine written. They're signed and dated by the testator in the presence of a notary and two neutral witnesses. They've got an attestation clause, but the language of the attestation clause is not the same as the language set forth in the Civil Code. And the court looks at it and says, nope, not good enough. This is not a valid will. So, if you go to a lawyer to get help writing a notarial will, and that notarial will does not contain word for word the attestation clause set forth in the Civil Code, then you've hired the wrong lawyer. And if there's no point in trying to do this yourself, because you got to have the notary sign this thing anyway. So, almost by definition, a notarial will be written by a lawyer. That's not necessarily true, but it probably ought to be. Um, and finally, the testator has to sign at the end and on each separate page. So typically on these notarial wills, you'll see at the bottom, on the bottom of every page, there will be a place for the testator to sign and date, sign and date, sign. There's 5 pages, bottom of each page, sign and date, sign and date, sign and date. Next slide, please. Now, here are some things to avoid, some things to keep in mind, some things to watch out for. Louisiana has traditionally been extremely tough on exact compliance with the formalities of wills. And there's a long line of Louisiana cases that invalidate wills for seemingly insignificant deviations from the requirements of the formalities of a will. But the rule in Louisiana is a defect in the required formalities renders the will absolutely null. And what that means is the court acts like the person died without a will, and the property goes to the next group of owners through the laws of intestacy. Recently, there has been some movement in Louisiana courts not to be quite so draconian about it, but that movement is not large. There is still a big tendency of Louisiana courts to adhere very strictly to the rules and the formalities of wills. Now, one of the things you have to watch out for is there can only be one testator per will. Believe it or not, I will occasionally see people come in and show me a will that is, a married couple trying to do one will for both of them at the same time. So it'll say, last will and testament of, James Doe and Jane Doe, husband and wife. That is invalid. That's not allowed under the civil code. Another thing to watch out for is that you can't have your agent sign a will for you. So if you have a power of attorney and you have appointed someone as your agent, that agent cannot sign your will for you. Doesn't work. There are also rules you have to watch out for witnesses. Every notarial will has to be witnessed. So obviously holographic wills don't have that requirement, but um, notarial wills require 2 witnesses, and the witnesses can't be insane, blind, under age 16, or unable to sign their name. Now, a legatee is a person who is given something in a will. So, if a person dies without a will, everybody who is entitled to take something under that will is called an heir. But if there's a will, everybody who has given something in that will is called a legatee. And the thing that they're given, the piece of property that they're given, is called a legacy. So if I write a will and I give my guitar to you in my will, well, you are a legatee of my will, and your legacy is the guitar. So if a witness or a notary is a legatee or a spouse of a legatee, that won't invalidate the will, but it does invalidate that particular legacy. So, they won't throw out the whole will and say, well, you died intestate, but they'll say, well, that legacy of your guitar is not valid because you gave the guitar to one of the witnesses or to a spouse of one of the witnesses. Okay, I need to change something on my screen here before we go on. Let's go to the next slide, please. Now, I want to say a few words about trusts. The fewer the better, I think. A trust is basically a legal arrangement where a person transfers ownership of their assets, money, property, investments, to another person or an institution called the trustee to hold and manage those assets for the benefit of designated individuals or entities who are known as beneficiaries. And the internet is full of people trying to sell you trusts. And part of the impetus for that is in a lot of states, the probate procedure or the succession procedure is not particularly easy or cheap or fast or convenient, or some things about it people don't like, so that you're constantly getting bombarded with these ads to avoid probate by putting your property in a trust. Now, my overall message to you is, if you want or need a trust, do not hesitate, do not pass go, go directly to a board certified attorney in Louisiana, licensed in Louisiana, board certified in estate planning and administration. If you need a list of those people, go to the Louisiana State Bar Association website, and there is a list of every estate planning board certified attorney in the state there. Don't do this by yourself. Don't hire somebody from out of state. Don't hire somebody off the internet. Don't use a do-it-yourself form. This is something you can't do yourself. There are tax consequences. There are all kinds of consequences to this, and you really need expert help with it. One of the selling points of this is supposedly that it helps you avoid probate, but there's a weird little fact, and that is, although Louisiana in way too many ways is kind of bringing up the rear of the national experience. One thing that we do really well is successions law. Our successions and probate procedure is, I think, one of the best in the nation. It's fairly cheap. It's fairly, particularly um, if there are no contests. If the heirs and the legatees aren't fighting it out in court, it's a really good procedure in Louisiana, and there's no reason to avoid it. Also, uh, you don't pay estate taxes in Louisiana until your estate is just many millions of dollars. So for the typical person that dies in this state, there are going to be no estate taxes. So there's no reason to attempt to do a trust to get around that. Uh, Now, there are some particular reasons that you might need or want a trust. One is that you can utilize an irrevocable trust, specifically called a Medicaid Asset Protection Trust, to protect your home from being counted as an asset for Medicaid eligibility for long-term care. But again, hire a board certified legal specialist for this. Don't try to do it yourself. Also, don't get confused between Medicaid and Medicare. This Medicaid trust doesn't do anything to protect your home against being counted as an asset and blah blah blah. It doesn't have anything to do with Medicare. It's Medicaid. Now, some other legitimate reasons to consider putting a trust into your will are you don't trust the heir's judgment or skill to handle the property you will be leaving them. And sometimes you hear the term spendthrift trust, which is basic concept is you can set up a trust so that you leave money to your irresponsible child, but you put it in trust so that the trustee controls how the money is spent and make sure that it's spent on things that should be spent on rather than frittered away on stuff it shouldn't be spent on. Um, you might consider a trust if you're extremely wealthy and you need a complex and sophisticated estate plan. If you're in that group, I hope you have already turned me off and gone directly to find an estate planning attorney. Or, and I run into this a lot, you might have a child who's unable to care for themselves and needs a special needs trust. That is really sadly pretty common. And again, go find an estate planning and administration attorney for this. It's really your best bet. It's your best way to move forward with the special needs trust. There are some, at least in Orleans Parish, there might be some help from some groups with helping you do that, but you're still ultimately probably going to need an estate planning specialist to help you. Next slide, please. Let me say something, one more point about trusts, and that is, if one of the problems of writing a will is you don't know. Not only do you not know how long you're going to live, or how long anybody else is going to live, but as a corollary of that, if you're looking today at leaving money to a minor, you don't know if that person's going to be a minor when you die or not. You might reach 18 before you die. But if you're writing a will today, leaving money to a child today, who's a child today, instead of putting that money in a trust, one alternative is to take advantage of the Louisiana's version of the Uniform Transfers to Minors Act. And that is codified in Title IX, Section 751 and following of the Louisiana Revised Statutes. But it's a law. It's one of these model laws that most states have adopted, including Louisiana. So what it does is it allows you in your will to nominate a person to administer that minor's property that you're leaving to them in the will until that minor reaches adulthood, at which point the property becomes directly owned by the minor and is no longer subject to being managed by the curator that you've nominated in the will. So you can write that right into the will without creating a trust, and it gets around the problem of, well, what happens if I'm leaving money to somebody who's under 18 when I die? Next slide, please. Let's talk about powers of attorney, simply because this is another aspect that can be an important tool in estate planning. And of course, we're in Louisiana, so power of attorney is not called power of attorney here. It's called procuration. And sometimes it's called procuration and mandate, but it's the same thing. It's a power of attorney. And what it does is it's an instrument, it's a writing that confers authority on another person to act for the principal. So the person granting the authority is the principal, the person who's receiving the authority is the agent. So we do a power of attorney, and I make you my agent, and I give you the authority to act for me in certain areas. Uh, and typically, a power of attorney will say, "I'll give you, general authority to do whatever is appropriate under the circumstances for me." But there are certain powers that, if I want you to have them, I have to give it to you. I have to set it forth um, expressly in the power of attorney. And that includes the power to buy, sell, mortgage, or lease real estate, make a donation, contract a loan, acknowledge or forgive a debt, become a surety, draw or endorse promissory notes and negotiable instruments, enter into a compromise of a legal claim or refer a matter to arbitration, make healthcare decisions, and prevent or limit communication, visitation, or interaction between the principal and a relative or another person. And if this last one makes you scratch your head saying, what's that all about? All I can tell you is I have seen several instances of powers of attorney causing strife within families because elderly parent gives power of attorney to one child. That child has the mother in an assisted living facility and tells the assisted living facility, "I forbid you to allow my brothers and sisters to see my mother. They're not allowed to visit her here." So, uh, does that agent have the authority to do that? Well, yeah, the power of attorney can give him that authority, but it's got to be express. Um, Next slide, please. So, other than being written and signed, there's no particular form required for a power of attorney. But Louisiana has a concept called authentic act. And an authentic act is a writing that is signed and notarized and witnessed by two people. And the basic purpose of an authentic act is to create a document that is self-proving if you ever have to use it in court. So rather than, you go to court like Perry Mason and you say, okay, I want to introduce this power of attorney into evidence. And you have to prove as a matter of evidence law that it's an authentic writing to make it admissible into evidence. Well, the purpose of having an authentic act is to do away with all that preliminary stuff and say, well, it's signed, it's notarized, and it's witnessed by two people, so it's self-authenticating. You can just put it into evidence and use it. That's the basic idea, and it's kind of goes back to a Napoleonic code idea that under that system, notary publics are kind of quasi judicial officers that have some responsibility to the public other than simply saying, I think the person who signed this is the person who they said they were. It's signed by Jimmy Smith, and I saw a, a driver's license he gave me that says Jimmy Smith, so I'm attesting that it's Jimmy Smith. Well, under the old French system or under the Napoleonic French system, notary publics had a little bit more authority and responsibility than that. And I think that's part of what lies behind this authentic act idea. But anyway, what you really would like to have, if possible, is a power of attorney in the form of an authentic act. So get a power of attorney that's signed in the presence of a notary and two witnesses. And the reason for that is so that it'll be more widely accepted. Just like you don't want to carry monopoly money in your wallet because nobody's going to accept it as real money. You don't want to carry a piece of paper around that says it's a power of attorney that everybody's going to look at it and say, this looks a little hinky to me. I'm not going to accept it. You want people to accept that power of attorney. And one of the ways to do that is to present it as an authentic act. And sometimes, no matter what you do, you will run into institutions, you will run into hospitals, doctors, banks, brokerage houses who, no matter what you give them, they'll look at it and say, well, this isn't the form that we use. We're not going to accept this. You know, the better part of valor at that point is to say, well, give me your form and I'll execute the form that you like to give to you for doing business with you. So if you run into somebody like that, usually the best thing to do is just use their own form. Let's go to the next slide. A power of attorney generally lasts as long as the principal does. So when the principal dies, the power of attorney expires, period. When the principal, if the principal is interdicted, the power of attorney is over, it expires. However, unless that power of attorney document states that it's irrevocable, the principal has the right to terminate the power of attorney at any time. So, for example, you sign a power of attorney giving your daughter the right to make decisions for you, and then, a couple of months later, you decide that your daughter is stealing your money. You notice your bank accounts get a little light, and she seems to be taking your money from you. Well, you want to revoke that power of attorney. You have the right to do that as long as you didn't make the mistake of saying this power of attorney is irrevocable. So don't ever do that. Always make it to where you can revoke it any time you want to. Also, the agent may resign at any time. So, your daughter agrees to be your agent because you're getting older and you need help making sure your bills are paid on time and talking with doctors and stuff like that. Your daughter signs it and then, she comes down with some horrible disease and just has no time or energy left to deal with it. She can resign. So one thing to be careful here is a lot of times people will do a power of attorney to make their spouse their agent. Me, for example, I've done that. My wife has done it too. We've done it for each other. And knock on wood, we're not getting divorced. But if we do, each of us needs to be aware that there is no automatic revocation of a power of attorney upon divorce. So if you are divorced and your spouse was your agent, you should seriously consider revoking that power of attorney immediately. And finally having a durable power of attorney can often mean relatives don't have to institute an interdiction proceeding if the principal becomes incapacitated. Now, that seems a little bit contradictory to the first point above under Civil Code Article 3024, that interdiction destroys the power of attorney, but it's just sort of an accommodation. In other words, if you have a durable power of attorney and you lose your marbles, your agent, can just kind of slide on by with that power of attorney as long as nobody has pulled the trigger on getting you interdicted. But if they do get you interdicted, the power of attorney is gone. Let's go to the next slide, please. I needed to say one more thing about the last slide. Can we go back? Okay, on how long the power of attorney lasts. The last point I wanted to make is that if you terminate your power of attorney, there's a certain class of people who, under Louisiana law, are entitled to rely on the public records. And here we're talking about real estate, okay? So if your power, remember, we said earlier that one of the things you have to give your agent specific authority to do is to do real estate transactions for you. So let's say you've signed a POA giving your agent the authority to buy and sell property. If you decide to revoke that power of attorney, it is not necessarily effective uh, against people who deal in real estate until you file the revocation in the conveyance records of the parish where you live, so or the parish where the property is. So if you own a piece of property, if you own any real estate at all, and you sign a power of attorney and you revoke that power of attorney, then you really should file a copy of the revocation of the power of attorney in the conveyance records of any parish where you own property and any parish in which you live, so that it is effective against good faith purchasers of property. Otherwise, you might find that your agent has sold your house out from under you. Okay, now, next slide. The I say I'm running slow. I'm running a little over time here. Uh, an agent is generally not personally liable to perform a contract into on behalf of the principal if the procuration is disclosed. In other words, if I'm your agent and I agree, on your behalf to do something and sign a contract to that effect, I'm not personally liable for the performance of that contract. If I told you when we entered into the contract, I am only doing this as Billy Bob's agent. This binds Billy Bob, it doesn't bind me. Also, the agent is liable to perform the contract if he exceeded his authority unless the other party knew it. So if I have a power of attorney for Billy Bob that um, does not give me the authority to enter into this contract with you, if you're ignorant of that, you can make me perform it. But if you and I both knew that, then you can't make me perform it. Finally, if I am Billy Bob's agent and I go out and do things for Billy Bob's benefit and incur expenses in doing that, then Billy Bob's got to pay me back for that. He's got to reimburse my expenses and any losses that I sustain as a result of carrying out my duties under or my authority under the power of attorney. Let's go to the next slide, please. So some of the landmines, some of the problems to watch out for with POAs are um, that a power to make gifts on behalf of a principal. Remember, that's one of the things you have to set forth specifically is to be able to donate things. If I have the authority to donate things as I'm your agent and I can donate stuff on your behalf, it can expose me to federal tax liability. So be careful about that. There's such a thing as a springing power of attorney that becomes effective only when something happens in the future. That is, this power of attorney only becomes effective if I become incapacitated in the future. The problem with doing that is you got to prove that the springing event occurred. So you probably have to go to court to make it effective. It's going to be a big mess. It doesn't work very well. We mentioned before, don't ever make the power of attorney irrevocable. Nothing good ever comes from that. And also, do not designate co-agents, because the problem is each of them gets a vote. If they don't see things eye to eye, then everything is at a standstill and nobody wins. So it can cause everything to come to a grinding halt when it takes care of the business of the principal. Also, don't ever put a power of attorney into the principal's safety deposit box, because how are you going to get the authority to unlock the box unless you can produce the power of attorney? It's a catch-22. Obviously, the same applies to a will. Don't keep your will in a lock box, in a safety deposit box, because the bank is not going to let your heirs or your legatees or your administrator into the box until they probate the will, but they can't probate the will if it's locked in the box. So don't do that. Next. Just a few words. I see we're at 1 o'clock here. I apologize for running late. Living will is a specific document. Uh, you can just Google. I mean, there's a link at the bottom of the page there, but if you simply Google Louisiana Living Will Declaration Form, it'll bring you exactly to where you need to go. This is a form where you can tell your doctors ahead of time what to do if you are in a persistent vegetative state and you cannot communicate with your doctors? Do you want them to keep trying to make heroic gestures, or do you just want comfort care and have them let you die? You don't want to do that with food or water or without. That's what the form is for. Next slide, please. Um, if you do that form, it doesn't require notarization. You download it from the state website, you fill it out, you follow the instructions at the bottom of the form, send the form into the state Secretary of State in Baton Rouge with $20. They keep it on file. Every doctor in the state knows it's there and they'll all follow it. Next slide. It's an explanation of the choices for the living will declaration form. Next slide, please. Next slide. Other things I want to briefly mention. One is called LA Post. And this is something that if you're interested in, talk to your treating physician about. It's like a living will declaration, but it's in much more detail. So, in addition to talking about hydration and nutrition and comfort care and all that, you can get very specific. Do you want them to perform CPR on you if you go into cardiac arrest? Blah, blah, blah. It's much more detailed than the living will declaration form, and it follows you around among institutions as doctor's orders. So if you're interested in that, talk to your doctor about it. He'll know what, or she'll know what it is. Next slide. If you have particular ideas about funeral arrangements, you might want to consider doing either putting in your will, or I think even better, doing a separate notarized document about who's in charge of your funeral and what authority they have. The problem is that funeral homes get sued if they do things with your body that are not authorized. So they could get pretty doggone picky about, some relative calling up saying, well, we want this or we want that, or we want cremation or we don't, etc. So one way to make your wishes known is to pick out somebody who's going to be in charge of it, do a document with them to set out what the arrangements are going to be. Next slide, please. Cremation in particular is subject to its own rules under Louisiana law. And the best thing you can do if you want to be cremated is to do a notarized affidavit in authentic act form saying, I authorize cremation of my remains. And we have a form for that we've developed. It's very easy, and it gives the funeral home cover. They now have the ability to cremate you without getting sued for it. That really is about it for me.
Thank you, Joe, so much. So we're going to go ahead and, I know we're a little over time, but we're going to go ahead and open it up to questions. Just a reminder, you can post any questions you have. If you're on Zoom, post them in the Q&A section. If you're on Facebook, you can post them in the comments. Do know those are public. We have gotten a few already, so I'm just going to go ahead and jump right into them, Joe. The first is, I'm not understanding the context exactly, but maybe you will. What if you have property, but your children are minors? And this came earlier in the presentation, maybe.
All right. My recommendation is either live long enough so that they're not minors when you die, or write a will disposing of the property in accordance with the Uniform Transfer to Minors Act, where you designate someone to administer that property for their benefit until they reach adulthood, at which point the property becomes theirs.
Next question is, can your executor be a person who is also in the will to receive something?
Yes. As a matter of fact, why would anybody agree to be an executor otherwise? You got somebody that you didn't even give them anything in your will, and you want them to go to all the time and expense to administer this thing? Come on, leave them something. Next.
Next question is, does a handwritten notarized will with 2 witnesses have to be filed with a court at the parish?
A handwritten notarized will is not valid. Don't bother with it. It's invalid. Throw it away. Get a valid will. That's answer number 1. Answer number 2 is no. In Louisiana, you do not file wills anywhere. They are only filed in court by your heirs, executors, when the succession is opened after you die.
Okay, for the written will, do you use the word executor or independent executor?
I always use independent executor because if you don't, the executor is going to have to go back to court and get a court order every time they want to tie their shoelaces. So always say independent executor.
Correct. Okay, next question. Does the hand, oh wait, nope, already answered that one. This is quite a few, so bear with me. Um, for the written, okay, you answered that. What does codicils mean?
A codicil is a change, it's an amendment to the will. You have the option to write a codicil to a will, or you can simply tear up the old will and write a new one saying, I revoke all prior wills and here's my new one, and write the new one over again entirely, which I think is the better practice. But you have the option, if all you want to do is change a couple of little things in it, to write a codicil to the existing will.
Okay. Can step siblings inherit from an estate, or can half siblings inherit from an estate?
It depends on their relationship to the decedent. In other words, well, first of all, if they're legatees in a will, obviously anybody can. You don't have to be related at all to be a legatee. But if you're talking about somebody who dies intestate, they die without a valid will, then the question is, who are the heirs? And the heirs are the descendants. So if they're the descendant of the dead, if the dead person is their biological parent, yes, they inherit. If the dead person has adopted them, then yes, they inherit. If the dead person is neither their biological parent nor their adoptive parent, then no, they do not inherit under the laws of intestacy.
Okay. Next question. What is a testator?
A testator is a person who signs a notarial will. In other words, that's the person who's saying, I, Joseph Robert Ballard, being of sound mind, do make this my last will and testament. I leave everything to Bobby. Signed, Joseph R. Ballard, testator.
Does an holographic will need to be updated?
Updated.
I don't
If
know the
uh,
context.
that I mean, any will, you would want to update any will if circumstances has changed where that will no longer does what you want it to do. Somebody new has been born, somebody old has died, somebody won a lottery, somebody got sent to jail. I mean, so whether it's holographic or notarial doesn't matter. If you need to change it and update it, you need to change it and update it.
Next question is, can I use a quitclaim deed as a way to give my property to my children? Will this skip the succession?
I wouldn't do it. A quitclaim deed is not really a, a totally not necessarily a totally effective way to transfer ownership of property. All it does is it says, I give you whatever interest I may have in this property. It's entirely different than doing either an act of donation or an act of sale to transfer the property. I would do one. I would either do an act of donation or an act of sale. I would not leave it to a quitclaim deed. Quitclaim deeds they're mainly useful if you are going back doing curative title work on you find that there's some defect in title because 40 years ago somebody forgot about an heir out there, and they ended up owning 1/365th percent of this piece of property. So you go to the descendant of that person and you get them to sign a quitclaim deed to say, whatever interest I may have in this property, it's now yours. Other than that, I would not use a quitclaim deed for anything.
Thanks. That was great. Next question, can I write my own will without an attorney? Will it stand in court as a legal document?
If you do an holographic will and follow the rules, yes, you can do it without an attorney.
Next question, upon death, how is everyone alerted that you have a will?
That's a good question. Um, you know what I do is if you write a will and you name an executor in the will, tell the executor you have a will. You know, um, give them a copy of them, tell them where the original is. Or what we do in my office is if we write a will for you, we do it in triplicate originals. We don't give you copies. We give you three originals. So, you can keep one and give one to your executor and one to your alternate executor. And that way, if somebody's house floods and their documents all get destroyed, then you've got two more shots at coming up with an original will. But you should name an executor in your will and tell your executor, hey, I wrote a will and here it is.
Okay, next question. Can more than one person be an executor? Do I have to appoint anyone as an executor? A financial advisor told me due to the large number of outdated laws in Louisiana, it would be better to have a lawyer prepare a will for me rather than myself.
I always think it's better to have a lawyer prepare a will for you. I'm a lawyer and I don't prepare my own wills. I hire an attorney to do it for me, but um, I'll hire a lawyer to do it for me just because I want a second pair of eyes to look at it. But what was the other part of the question?
Can more than one person be an executor and do you have to have one?
Yeah, yeah, you can name co-executors. It's a terrible idea because each one of them gets one vote. What happens if they don't see eye to eye on something? There's a piece of property and they have to decide what to do with the property, and one wants to do this and the other wants to do that. Well, they've got to go to court and partition the property, or they got to go to court and fight it out over who's going to be the what's the court going to allow them to do with it. It leads to these traffic jams that are intractable. I would not do it. Now, that's not the same thing as naming alternate executors. In other words, I name person A to be the executor, but if they either refuse or are unable to be the executor, then I would name B as the executor. But there's only one of them who's the executor. It's either the first one, or if they're not able to do it, then the second one.
All
And
right.
it doesn't have to stop with two. You can name 10 in a row if you want, going down that list.
We still have a few more questions if you're okay answering them. If I have a valid will and I move and or die in a different state, is my will still valid?
Should be, yeah.
How can I avoid probate?
Don't die. Sorry, smart ass answer. Um, First of all, there's no reason you should avoid probate. But again, the internet trolls say that you can avoid probate by putting all your property in a trust. Uh, I don't recommend it, but buyer beware.
What should I do with my will?
Um, I would uh, keep it in a safe place, and I don't mean in a safe deposit box in your bank. I mean, in a like a fireproof safe in your home, and let your executor and your loved ones know where it is so they can find it.
Should I have a copy of my will? Should I give a copy of my will to someone?
I would give a copy to the executor. uh, you know Depending on your circumstances, you may want to give out more than one copy of your will, depending on what it says and what your circumstances are.
What if you decide to donate your body to science?
um, that is something that you could put in the will. uh, I think that it would probably be better to just do that in a separate document. First of all, I think it'd be a really good idea to contact specifically who it is you want to leave your body to. Are you leaving it to the people in Tennessee that put it out in the field and watch the insects eat it? Are you donating it to a medical school? Are you donating it to somewhere else? In other words, whatever organization you're donating it to, I think it would be a good idea to contact that organization and see what's involved in setting that up ahead of time, rather than making it some intractable ridiculous headache for your executor to try to figure out.
What if you die without a will and you are single?
Same thing. Presumably, you have no community property. It's all separate property, and your separate property goes according to those classes of heirs. In other words, if you have children, they take it. If you have no children, but you have siblings, they take it. If you have no children, no siblings, but living parents, they take it. You don't have a surviving spouse. If you've got grandparents, they would be next in line. Other relatives, third cousins and stuff would be the next group. And if all that fails, the state takes it all.
Are there capital gain consequences to donations?
I don't answer tax questions.
Okay. I was gonna say that's a doozy of a one. Can power of attorney change beneficiary of a life insurance policy?
No. Well, that's a good question. I would think the answer would be no. It may be a matter of what the insurance company requires, because they're a co-contracting party. They may have their own rules about that. They may not allow that. Um, I really I don't know the definitive answer to that.
And then last question, can a law firm be an executor of a will?
Yes.
All right, those are all the questions I'm seeing. Um, I will give it another minute, but I'm gonna go ahead and go to our next slide to provide some more information. Um, so here are a few additional civil legal resources that might help. Or if you have a legal question that was not addressed during this presentation and you need help getting assistance, please go to the LSBA's Find Legal Help portal. There you can access our attorney directory, the Civil Legal Navigator, legal aid and pro bono organizations such as the Pro Bono Project that Mr. Ballard works for, the Modest Means Directory and self-help services and other resources. But first, I'd like to call attention to the Louisiana Civil Legal Navigator. This is a free online tool that helps you identify your legal issue, and then it will provide customized resources, information, court forms if applicable, referrals to legal aid if applicable. It's really a great starting point, especially if you don't know where to start. So that's the Civil Legal Navigator. You can click on the button from the Find Legal Help portal. The second that I'd like to point out on the portal is Free Legal Answers, which is another online free pro bono program. Please note that users must meet certain income guidelines to use the program, but if you qualify, it will allow users to log in whenever and wherever they like. You can ask your civil legal questions, which then attorney volunteers may answer those questions, and it's all through the site. It acts almost like an email exchange, but it's between you and the volunteer attorney. Again, you can find these resources on the LSBA's Find Legal Help portal, which you can access by going to www.lsba.org/go to/find legal help. The link is up in the little navy blue box at the top of this page. Okay, we did get one more question. Um, with bond or without bond, what is the significance of that phrase?
That refers to the executor. Is the executor going to be required to post a bond to a surety bond to protect against the risk that the executor improperly razzoos the money that they're supposed to be administering? So if the executor, steals the money instead of getting it to the people that it should go to the legatees, who bears the risk of that? So if you don't trust your executor, then you would say with bond, and they would have to file a bond to, you know, protect against the risk of their stealing the money. To which I say, if that's what you think of your executor, pick another executor.
That's the last question we have. So that will conclude our Law Talks workshop for today. Please save the date for our next Law Talks, which will be on types of adoptions. That will be held on Wednesday, September 17th at 5:30 p.m. You can go to the link shown on the page, www.lawyersandlibraries.org, if you'd like to register to watch by Zoom or get a link to the Facebook event. Joe, thank you so much for the presentation today. You shared a lot of really great, useful information. And I know we went over, but I appreciate everyone participating. And there were a lot of questions, and thank you for getting through all of them. It was really very helpful, I think, for all of us. So thank you so much. I hope you have a great day, and everyone else attending, have a great rest of your afternoon.
Thank you.